but only when its rules are clear, predictable, and properly balanced. Today, at the threshold, they are not. Congress should decide what belongs in the patent system and give American innovators the confidence to invest, to build, to disclose, and to keep the next generation of breakthroughs here at home. Thank you, and I look forward to your questions.
Thank you. Just at the outset, I had the great privilege of meeting Senator Graham a few times in my career, and I just wanted to briefly say that I join with countless Americans in offering my deep condolences to Senator Graham's family and to his friends and his colleagues for your tragic loss. Chairman Grassley, Ranking Member Durbin, members of the committee. My name is John Lee, and I am the Senior Director and Head of IP Policy at the Computer and Communications Industry Association. Our members include some of the most innovative and prolific patent owners in the world, and they depend on a strong, balanced patent system to support innovation, protect IP, and encourage economic growth. It's a great privilege to be invited to testify here today, and I appreciate this opportunity to share our insights on this important topic. In my opening remarks, I'd like to focus on three key points: predictability, innovation, and protection. First, predictability. Now, despite some claims that the sky is falling when it comes to patent eligibility, the current state of that law in the United States is cogent and consistent. And how do we know that? Empirical data has revealed that patent eligibility decisions today are remarkably reliable and are seldom reversed or even draw a dissent on appeal. A recent study in the Iowa Law Review found that since 2012, district court decisions on patent eligibility have been affirmed more than 85% of the time. And decisions from the USPTO have been affirmed more than 95% of the time, usually unanimously. This and other data shows that courts understand the patent eligibility rules and apply them accurately to reach the correct result in the vast majority of cases. And this shouldn't be that surprising, because patent eligibility law has actually been largely consistent for over 170 years. Which brings me to my second point, innovation. Consistent, predictable patent eligibility rules have contributed to more than a century of American innovation and technological leadership. And more importantly, current law continues to support robust innovation, including in many of the areas we've been talking about already, like artificial intelligence. If the current patent eligibility framework were suppressing innovation, as some say, we'd expect to see it reflected in the data, but in fact, we see the opposite. For example, the USPTO issued approximately 50,000 artificial intelligence patents last year alone. It's almost double since the Supreme Court's Alice decision. R&D spending has also increased in that time period, including in the industries most affected by Section 101, such as software, including AI. Venture capital investment in AI has also skyrocketed, with the United States receiving 75% of global VC funding in the AI sector just last year, a total of about $200 billion. Importantly, the United States received about 12 times as much VC funding in AI as the EU, which came in second place, and 15 times as much as China in third, which casts doubt on those who claim that the Supreme Court's Section 101 cases are disadvantaging U.S. companies. And that brings me to my third point, protection. One of the ways patent eligibility rules contribute to innovation is by shielding innovative U.S. businesses from low-quality patents. Without reasonable limits on patent eligibility, litigation brought by rent-seeking patent assertion entities is likely to rise. Patent assertion entities often wield low-quality patents on abstract ideas, like sorting or organizing information, with only token recitations of generic computers or devices. It's exactly what Section 101 is designed to address. Section 101 protects U.S. businesses targeted by such low-quality patents, which frees resources and reassures investors to boost innovation. For example, a recent study found that VC funding to the industries most affected by the Supreme Court's Alice decision actually increased by 42% after the Alice decision. Now, this study also revealed that the reason for that increase was directly related to the protection provided by Section 101 against spurious litigation on low-quality patents. In closing, we are living through one of the most consequential periods of technological advancement in our nation's history, with American leadership in areas like artificial intelligence, biotechnology, and advanced computing reshaping our economy, society, and the world. Section 101 is part of that success due to the three key points about patent eligibility that I described: predictability, which boosts innovation, including by protection of U.S. businesses, all creating the balance that the patent system needs to continue promoting these and future innovations as it has for well over a century. I commend the committee for taking a thoughtful approach to understanding patent eligibility, and thank you for inviting me to testify on this important topic.
Chairman Grassley, Ranking Member Durbin, and members of the committee, thank you so much for the opportunity to be here. Before I get started, I also want to join others in saying I'm deeply sorry for the loss of your longtime colleague and friend, Senator Graham. And Senator Durbin, thank you for sharing your personal stories. My name is Sue Peshin, and I serve as President and CEO of the Alliance for Aging Research. At the Alliance, we are changing the narrative to achieve healthy aging and fair access to care. Personally, I'm also a family caregiver to my mom, who is 85 and lives with kidney disease, arthritis, and dementia. Today's hearing is not an abstract policy debate for older patients and family caregivers like me. This is about lives, choices, and hope. It's important to understand why passage of the Bipartisan Patent Eligibility Restoration Act, or PERA, has become urgent. For 15 years, the U.S. patent system has struck down thousands of patents and failed to protect some of the most transformative innovations in diagnostics, not because they weren't new or useful, but because a series of Supreme Court rulings created confusion when broadening patent ineligibility and invalidation. The problem is especially severe in medical diagnostics. The Supreme Court's expanded exceptions for laws of nature, natural phenomena, and abstract ideas have made many diagnostic inventions ineligible for patents. As a result, the Patent Office often rejects applications for methods